Members, Senate Bill 625, Child Welfare Safety and Permanency Reforms. I do have an amendment, and I will present the amendment, and then I'm going to let Senator Batch and Senator Jarvis go through the bill. They have done yeoman's work on it. We've worked with the department. Everybody's had input. I do want to let you know that we are also working with the administration of the courts. They had some changes that we're working on, and we will be making those when this moves to the Judiciary Committee. But first of all, I have the amendment to present.
Go ahead.
The amendment is actually, in the course of working on this child permanency, I read an article about a couple that had lost their children because they had not reimbursed the state. I had no idea that these families, when their children are taken into foster care, are actually billed for those services. I did not know that. This family had worked really hard, gotten themselves back on track, and regained custody. They had 3, regained custody of 2, but 1 had already been adopted. And so what this bill does, Senate Bill 443, is the amendment. And it will actually set up a plan. We've worked with the department. The department actually had been wanting to do this for a long time, make changes to this program to work with those families to repay those debts without losing their children. So that's what the amendment does, and I'll be glad to answer any questions.
Thanks, Senator. Any questions from members on the amendment? Hearing none, motion to be in order. Senator Hayes moves to adopt the amendment as presented. All in favor say aye. Opposed? That motion passes. Now we're back on the bill.
Thank you, Mr. Chairman, and Senator Batch and Senator Jarvis will walk you through the bill.
Thank you, Chair, and thank you, Senator Krolik. So we are here today to present the major parts of the bill. It's very lengthy, so we'll just hit the high points. The first is that this is a bill that will actually improve the quality of practice and legal representation in our DSS courtrooms. Currently, DSS attorneys, contract attorneys, are not required to take any type of legal education regarding juvenile law. Juvenile law is very unique, and so we are asking for those attorneys who represent DSS agencies and local agencies to actually take 6 hours of legal education on child welfare law before they even start representing children, and then 6 years of the 12 that they have to have for continuing legal education every single year. We also have talked about, and one of the issues that we have seen in some of the counties are that foster parents and relatives who have had a child for over a year in their care have DSS come in and remove the child without any notice to the foster parent, without any notice to the relative, and the court usually doesn't find out until they've been removed. These are children who the relative wants to adopt or the foster parent wants to adopt, but the agency decides they're just going to remove them. So they have no appellate process. There's no appeal, there's no right to be heard. So this new section actually allows for the process when the child's plan is adoption and the foster parent or relative wants to adopt. That child's been there for 12 consecutive months. They actually have to go to court to ask for a judge to remove the child before the child is removed. So this is going to, of course, address a lot of issues where there are, sadly, as many of you have probably heard from constituents, families that have lost placement of a child who they wanted to adopt simply because they disagreed with the DSS office and the decision that they made. The other section that we're talking about are TPR grounds, and so with regards to Senator Corbin, Senator Bergen, and Senator Krolik, thank you for your work that you've done on the child support arrearages. What we have in North Carolina, and you guys have heard it from Senator Krolik, you've also heard on NPR and other stories, that we have been terminating the parental rights of parents because they fail to pay child support. So this bill, and we're amending the termination of parental rights statute to remove the provisions that allow for you to terminate just on failure to pay child support. And then we, of course, had to change adoption statute to amend for those changes. We also removed the paternity statute and then, put portions of that into the neglect statute. There should not be a world in which parents just happen to be poor and we're terminating their rights because of that. So this is actually one of the ways in which we can correct for that. And then, of course, with their bill and all of their work on that, we will be able to, of course, forgive the arrears that currently exist for so many families out here right now who are just trying to get by but have a significant debt to the state.
Thank you, Senator Batch. Senator Jarvis.
Thank you, Mr. Chair. Thank you, committee. I'll just touch on the post-adoption contracts for DSS cases. Our statute currently does not allow for prospective or adoptive parents to relinquish parents to enter into a contract, to have some form of a contract after the adoption is complete. Many parents, I believe, would be willing to relinquish the rights, their parental rights, if they had the assurance that they may be able to get emails, pictures, possibly a phone call at some point. By allowing post-relinquished contracts, I believe this will expedite permanence and increase adoptions across our state, while decreasing the amount of appeals that goes to the Court of Appeals. It also allows for the court to modify or terminate ongoing contract in the future. If the court determines that it's not in the best interest, it's no longer in the best interest of the child, they are able to terminate that contract. And I think so many times we do not put the child's rights before the parental rights, and I think we've got to do what's right for the child. Thank you. Senator Crowley.
Thank you.
Mr. Chairman, we'll be glad to answer any questions.
Thank you for the presentation. Questions from members or comments? Senator Gailey.
Yeah, I have a quick question. I had a constituent who went through a horrible, horrible experience, was a foster parent who had a child removed from her custody who she and her family were intending to adopt. Would this bill, when a child is removed and by DSS and they go to court, like Senator Batch was mentioning, does that foster parent in this bill have the right to cross-examine witnesses and present their own witnesses? And or do the rules of evidence apply in that hearing?
Other comments or questions from?
It was a question.
That was a question for Senator Batch or for any of the
For
bill
you.
sponsors.
Okay.
I was just waiting for you to.
Sorry.
Yes, great question, Senator Gilley. So what we actually do in this bill is before the child's even removed. So long as there's not a safety issue, the child will not be removed. And it is incumbent upon DSS before removal to file that motion. At the hearing, currently under law, foster parents have the right to actually speak at hearings regarding the welfare and the well-being of children. And so they have the opportunity to address the court already. So that's already codified in our statute. And so what this will mean is that a hearing has to be taken place with a guardian ad litem, DSS attorney, and of course other parties, caretakers, and parents are represented. And then prior to the removal, there will be a hearing where a judge makes the decision about whether or not the child needs to be removed.
Follow up.
Thank you. So I understand you saying that the foster parent has the right to address the court, but does the foster parent have the right to cross-examine witnesses or present their own witnesses?
At the hearing, that this new version of the bill that we're actually creating right now.
Either there or any point in the process.
So prior to that process, no, because they're not considered a party to the case. They can be considered a party if they meet the statutory grounds that are required in the termination of parental rights statute that gives them standings pursuant to 401.1. Prior, and that's actually the amount of time that a child has stayed. So foster parents actually do, or caretakers, relatives can intervene in these cases so long as they've had the child for that statutory amount of time. We do not have a provision specifically in here. I'm happy to work with you between now and the judiciary to go ahead and address some of your concerns.
Follow up.
Thank you. I would be interested in exploring that a little bit more. Thank you.
Senator Bergen.
Thank you, Mr. Chairman. Senator Batch, just a follow-up, and walk me through just I've been trying to figure this out, and I know you're an attorney that deals with this all the time. One of my big concerns has been termination of rights, about the kids that go back and forth in long periods of time, and just walk me through what termination of parental rights is going to look like so we can get the kids into a permanent home as quickly as possible.
So with the great work that was done in 693 last year, we actually shortened the amount of time that a court needs to establish a permanent plan for a child. Pursuant to our statute, reunification is the first plan. It's the purpose of the juvenile code. But then once that's not identified within the first 9 months to a year, you're going to have a permanent plan. When a parent is no longer, and we have concurrent planning in North Carolina. So sometimes you can have a plan for reunification and adoption. The DSS agency is supposed to work on both. So once adoption has been identified, the DSS agency or the guardian ad litem within 60 days is supposed to file a termination of parental rights action. And then, again, I would love more court time, but a hearing is supposed to happen within 90 days from that time frame. And so that should be the process that actually occurs. As soon as adoption becomes the permanent plan for the child, the court should actually directs the agency to file the petition within that time, and we need to be much better at making sure that those hearings take place.
Follow up. Thank you. That's my whole problem. It seems like that's the problem, is that there is a plan. The plan's not followed. It keeps getting continued. So how do we make sure the plan's followed and something happens and it doesn't just keep going on and on?
Yeah, that's an excellent question. So one of the challenges that we have is that I've practiced from literally the mountains to the coast representing individuals in the child welfare space. What I will tell you is in many of the rural counties, they meet once a month for DSS courts. Right? They need more time. We need judges to be able to hear the cases. And what ends up happening is when you only meet once a month, you're only dealing with your entire caseload. And so those cases continue every single iteration. And so what I would say is that they're already a priority in the courts. This is a practice issue that we need to address and partner with AOC to make sure that courts are having the resources to get rid of their backlogs and follow that process.
Follow up.
Last one. Another problem I've seen is that kids end up in front of multiple judges that don't know the case, don't know the history, don't have time to read the case. Can we deal with that?
I would love to deal with that, and we'll definitely bring that to the attention of AOC when we speak with them next week. The challenge is that, as of right now, only family courts have the one judge, one rule, and we don't have family courts across this state. And so in all of the family courts, one judge will hear the case, and it's continued. But when I've gone to these other more rural counties don't have the same judge, we do hear 4 and 5 judges, and it's hard to keep up with the intricacies of that child's life and what has happened since they came out of care. And so I would love to see a model or at least some effort and perhaps a pilot program to address how we have one judge, one family, so there's a continuity of care not only with the child in foster care, but also in the court system.
You good?
I'm good.
Questions from other committee members? How about comments or questions from anyone in the audience? Seeing none, Senator Batch moves for a favorable report for Senate Bill 625. The motion is for a favorable report for the bill as amended, rolled into a new PCS with referrals to judiciary and rules. All in favor of that motion signify by saying aye. Aye. Same sign. That motion passes. Thank you.
Thank you.